So, the case law on expert opinion evidence. How do we know if your evidence is admissible? If you want to get your expert opinion before the court, you really need to understand these cases. So, in the case of Mohan, the Supreme Court gave us a 4-part test. The evidence has to be relevant, necessary, it has to not be subject to a rule of evidence that would otherwise exclude it. That's number 3, no other exclusionary rule. And you have to have a properly qualified expert. We're going to dive into each of these factors in more detail. Then the case of White-Burgess, which was later, comes along, and it takes that Mohan test and it adds a little bit to it. So everything from Mohan is still relevant, and then White-Burgess adds a requirement for reliability. So we now have 5 factors to deal with. We're going to talk about reliability. And then after we deal with those 5 factors, White-Burgess says that the judge has to do a little balancing exercise and decide if the benefits of the expert opinion evidence are worth the cost of including it in the litigation. We'll talk about that too. So moving on to the first Mohan factor, relevance. So we know that Jamie and Taylor's real estate appraiser is offering evidence directly related to the subject of the dispute. How much does Jamie need to pay Taylor to buy out the home? But what if Jamie and Taylor had a marriage contract, like a prenuptial agreement? So we've got a case up here, Cohen and the estate of Cohen, from ONSC, which is the Ontario Superior Court. And in this case, the court held that when we're dealing with a marriage contract, and we're trying to decide, is this prenuptial agreement valid? Then evidence about the value of the assets included in the agreement is not relevant when we're dealing with that question. And you can understand why. If the court finds that the prenup is valid, then the court doesn't need to think about the value of Jamie and Taylor's house. We already know what's happening to it based on that marriage contract. If the contract ends up being invalid, or if it's vaguely worded and there's still an issue to be determined where the value of the home becomes relevant, then the expert evidence becomes relevant again, and we've met the first Mohan factor. And then we move on to the second one, necessity. So, to understand this, let's imagine that Jamie and Taylor have another issue in dispute. It doesn't matter what it is, but for some bizarre reason, it's important for them to know what time the sun set on June 10th, 2017, and whether or not it was raining on that day. Sounds weird, just go with me. Now you might wonder, do they have to get an astronomer to testify about what time the sun sets at? Or do they need to call a meteorologist to testify about the weather on that date? Well, they don't need to do that, and in fact, they can't do that because of this Mohan factor. The court is able to determine those facts on its own. That's something called judicial notice. It's a whole other area of law we're not going to get into for now. Just accept that these sort of uncontroversial facts that can't be the subject of reasonable dispute, you can look them up in a farmer's almanac or something like that. Those are the sorts of things the court can take judicial notice of. That's an oversimplification. Just go with me. But because they can, it's not necessary to call an expert, and therefore, with this Mohan factor, the evidence is going to be excluded as not necessary. There's a couple of other ways that this factor works to exclude expert opinion evidence. One that I'm going to specifically point out, you can't call an expert just to say that the other party is lying. So Jamie gets up on the stand, says a bunch of stuff. Taylor says Jamie's lying about one of those things. You might think you could call some sort of behavioral psychologist who's an expert in body language or something else to testify that Jamie probably wasn't telling the truth. You can't do that. That's the judge's job, or it's the jury's job in a jury trial. That's a function of the court. And because it's a function of the court, it's not necessary to call an expert to help the court with it. And so this, among other reasons, is why you can't call an expert to say that the other party is lying. It really has to be something that's necessary to help the court do something that it can't do on its own, like determine the value of Jamie and Taylor's house, or have a child psychologist testifying about the nature of a child's relationship with one or both of the parties. So, moving on to the third Mohan factor, no other exclusionary rule. To be honest, this isn't particularly likely to come up in your case. Remember that Mohan covers criminal law, civil law, complex commercial litigation, not just family law. And we also just don't have time to go through all of the exclusionary rules relevant to evidence law. You've probably already heard of them. For example, if you've ever watched a legal show, I bet you've heard of the hearsay rule. That's hearsay, objection. That's probably not going to come up with your expert opinion evidence, and most of the other exclusionary rules probably aren't going to come up either. So I really wouldn't worry too much about this factor. If you have some sort of really weird opinion evidence, you might want to do some extra research. Also, evidence law is kind of interesting, so there's lots of YouTube videos available, and you could spend hours, probably days, going down the rabbit hole of what these kinds of exclusionary rules are. But for now, don't worry about it too much. Maybe do a little bit of extra research if you're worried about it and it sounds really weird. But we're going to move on to the fourth Mohan factor because this comes up all the time: the properly qualified expert. So take a look at Rule 20.2 sub 2 here on the screen. It's another chance for you to pause the video and look it up on CanLII as well. The Family Law Rules, Rule 20.2 sub 2. This outlines what the court's going to be looking at to qualify the expert. And there's a lot here. So, there's some timing restrictions that you see on screen of when the report has to be served and filed with the court. And then it goes into great detail about what needs to be included in the report. Of course, it's got to include the expert's name, address, and area of expertise. The expert's qualifications, including their employment and educational experience in the area of expertise. We're not just talking about a resume here. You want a very detailed CV that goes through the research that the expert has done, the publications that they've done, especially in peer-reviewed scientific or academic journals, conferences that they've presented at, courses that they've taught, really all the detail of the experience that they have to give them the expertise. Now, some experts aren't necessarily going to have an incredible amount of detail there on the CV, but some will. Some will give you a CV that's pages and pages and pages long. You want as much detail as possible because it reinforces the expertise of your expert and makes them more reliable to the court. Then you're going to need, the report has to set out the nature of the opinion, why it's relevant to the issues in the case, where it's relevant, the instructions that they got with regards to preparing their opinion in the case, what their opinion is, if there's a range of opinions, where their opinion falls within the range, why it falls within the range, and speaking of why, a detailed report of reasons for their opinion. So let's think about a real estate appraiser. They're going to give you a whole bunch of facts about the home that they're appraising. They're going to talk about the square footage. How did they determine the square footage? Did they use a measuring tool with every single room, or did they just look at an old real estate listing? They're going to talk about how many bedrooms, how many bathrooms, the quality of the fixture, on and on and on. Tons and tons of detail about the house. Then they're going to look at other houses, similar houses, in a similar market. They're going to tell you why those houses are in a similar market, why they're similar houses, a bunch of details about those houses, how they came up with those details. And those are all sort of lists of facts. The market might involve some opinion. And then they're going to tell you how they used all of these facts to come up with their final opinion of the value of the house. And you can see how that fits in to these requirements here in 4 and 5. And then they also have to provide an acknowledgement of their expert's duty, which we're going to get to in a minute, on Form 20.2, signed by the expert. There's a couple of cases here which really help us understand this. So in the Zrimiak case, we have a good discussion of facts versus opinions. Here there were some letters from a special education teacher that were rejected for the opinions that those letters expressed, but they were accepted as evidence for the facts. So that's like we were talking about in the appraisal. They'd be accepted as evidence for the square footage of the house, if that was relevant for some reason, or how many bedrooms there were, if that was relevant for some reason. But if these rules aren't observed and the opinion is rejected, then that conclusion on the value would be rejected. And it's really important to understand the difference between facts and opinions. In Zrimiak, the rules related to expert opinion evidence were not observed, and therefore it was inappropriate to rely on the opinions in the letters, but they accepted the facts. And then here in the LaRoche case, we had one of these participant experts, a treating psychiatrist. They were treating one of the parties, not a child in this case, but they testified to this party's unstable mental health. And that's okay. But then they offered an opinion outside of the scope there, which was that the party couldn't work. And they didn't provide expertise and qualifications about how they could determine that. And since it was outside the scope of their expertise as a participant expert, they would have had to do like this full report. We're going to talk about that in the duties of experts in a minute. They didn't do that, and so the evidence was excluded. So we've mentioned duties of experts a couple times, so we're going to talk about that now.